Right.
So, though the Constitution expressly made the provisions of Article 19 applicable, which would include these three rights, and Article 16, by enacting 35A, you virtually took away the fundamental rights.
A challenged on the ground that it violates the basic structure.
35A, it is, there are 5 petitions pending.
No, but that's, before that it was never challenged.
They were challenged at the relevant point of time, could never be decided. I think
was 2014 when
since long. Lord, kindly see, my lord, the impact of this. The cutoff date was, my lord, I am told 1927. So whoever came in Jammu and Kashmir in 1927 were permanent.
That's the law. What is the provision itself? It says it's not, the judicial scrutiny is therefore prevented because.
Now the impact was, for example, people from Jammu and Kashmir, people from Pak-occupied Jammu and Kashmir, Pak-occupied Kashmir, POK, were driven out, both Hindus and Muslims. But they were driven out in 47 during those raids. They are not permanent residents. They were not permanent residents till 2019. There were large number of Safai Karmacharis who have filed a petition, my lord, or intervention application, who were brought from other states to do, my lord, the manual work of cleanliness, etc. They are not permanent residents. They are not getting any of these benefits. Despite living for decades together, no person, my lord, beyond outside Jammu and Kashmir can acquire property, meaning thereby no investment.
So from this point of view,
Yes.
I was just looking at the 1954 order, CO 48.
Yes.
That applied the entirety of Part 3
Yes.
and then made certain modifications. Therefore, Article 16 applied, Article 19 applied. But now see what happens. If you look at the CO, it applies Part 3. That is Volume 3. You get it at Volume 3, page
14 months.
Page 14.
Yes.
Volume 3, page 14. But you bring in Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of immovable property, 3, settlement in the state. Leave aside scholarships. So though Part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19,
14.
and 16(1). Then you are taking away the right to acquire immovable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e).
Right.
So though the Constitution expressly made the provisions of Article 19 applicable, which would include these 3 rights, and Article 16, by enacting 35A, you virtually took away the fundamental rights.
Employment is also right to life.
Right, but there's a direct right under 16(1).
Yes. No, employment is a separate right and would fall within separate category of right to life.
No, that itself was not taken away. What was taken away was employment under the state government. Because what 35A did was, it says conferring on such permanent residents any special rights and privileges or imposing upon any other persons, any restrictions. So it does both things. You can give special rights to residents and you can take away that right insofar as non-residents are concerned. Employment under the state government. Employment under the state government is expressly covered by Article 16(1), because 16(1) says there shall be equality of opportunity for all citizens in matters relating to employment under the state. That includes the union as well as the states. So while on the one hand, Article 16(1) was preserved, 35A directly took away that fundamental right and granted immunity to any challenge on the ground that it would deprive you of a fundamental right which is protected by 16. Likewise, 19. 19 recognizes the right to reside, settle in any part of the country.
Right, to acquire property.
And property then was 19.
Now it is 300.
So all three fundamental rights were essentially taken away by 35A,
And
which
it
was brought in by CO 48.
It continued till 2019.
Power of judicial review was taken away.
Judicial review was taken. So it is beyond 9th schedule. Almost put at par, beyond 9th schedule also. And this continued till 2019, till the impugned resolution, impugned CO was passed. Therefore, my lord, I am respectfully urging that please look at the matter from the point of view of people of Jammu and Kashmir. Something which is impugned before your lordships is a constitutional exercise of power which confers fundamental rights, which applies the entire constitution, which brings the Jammu and Kashmir people at par with their rest of brothers and sisters, and Lord applies all laws which are welfare legislations, and I have the list which was not applicable.